The following program is for informational and educational purposes only. It is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And thanks for joining us on Fraudsters Radio. I'm Lori Z, consumer advocate, along with my co-host Storm Bradford, owner of Mortgage Fraud Examiners. Storm, we're going to be talking about foreclosure rescue scams today.
Yes, we are. And you, as a consumer advocate in Florida, are going to discuss your experiences with it. And in a short while, we're going to have Bob Hurt, another consumer advocate in Florida, and he's going to discuss his experiences with it.
Right. And my experiences, have been kind of scary, some of the things that I see or people ask me about, because they just don't make any sense. And also, let me tell you, when it comes to foreclosure here, I work as a credit consultant, and during when the bubble burst for several years, I got calls almost daily from people who wanted to hire an attorney, but it was never explained to them that the attorney is a foreclosure defense attorney, that they actually don't do any offensive action. And I would hear excuses like, I don't want to litigate, I don't want to go to court, I really don't want to leave my office, I just don't, I only want to do loan modifications or, help them with deed in lieu or file out in bankruptcy or foreclosure. No one actually wanted to take cases, and I'm going to tell you that I emailed, mailed, and called somewhere between 100 and 200 attorneys over a couple of year period, and I'm kind of shocked at that. I mean, what do you think? Is it every state, or is it just Florida where you can't find an attorney that'll do this?
Well, actually, it's everywhere, and the reason why is because inherently the lawyers understand that a foreclosure case is a breach of contract case. They understand that the homeowner breached it, but because they don't know how to analyze mortgage transactions, they don't know how to attack the transaction. So as one lawyer put it, that our company did an analysis for, he said, Storm, if you gave me or any other attorney in this country from now until the end of the millennium, there is no way that we could find what you people found in that analysis. We don't know how loans are underwritten. We don't understand the inner workings of banks. We wouldn't know how to analyze a appraisal, whether it was right or wrong. So the only thing that we have is to try to stall as long as we can. So,
well, I find that disturbing, though, Storm, because if you think you really do have a legitimate case, something is actually wrong, there's a contract breach, there's fraud in the inducement, the fact is you can't find someone to represent you. I guess it holds out that they're foreclosure defense, but when I would get phone calls, I would always say to the person that called me, hey, how many cases did your attorney win? And they would always go like, what do you mean? Well, they're foreclosure defense. I mean, how are they won? And so everyone seemed to think that was a bizarre question that I asked, but I don't think it's that bizarre. And I know we've talked in previous shows, about attorneys that say they won, hundreds or thousands of cases, when in reality they were just pretender defenders and stalling out the court case. Most of them who say I've won, they've really never won anything, right?
No, they haven't won anything. They, I hear all the time where these victims of these attorneys will say, well, you just don't know about all of the settlements that have gag orders on them. And I said, there are no settlements with gag orders on them. We looked at the cases, we looked at the underlying arguments, and none of the underlying arguments that were made by these stall attorneys had any merit to them whatsoever. So nobody, in actuality, ever settled one of those cases, and there was no gag orders. This is the homeowners that are now drunk from the Kool-Aid that's being served up by all the scammers, and they just don't understand what actually happened in the cases that are out there.
Well, I've heard some bizarre things, and have you heard of this? Is a new one that you can copyright a mortgage, and because you've copywritten that mortgage, they can't foreclose. Have you heard that one?
I've heard it. It's some crackpot by the name of Ken Dost has been telling people this for the last several years. It's utter nonsense.
I believe that too. And when I first talked to you, which was many years ago, I don't know if Ken Dost was a fellow. I thought his name was Ken. He was a mortgage person. But for example, with your company, you have legal professionals examining the mortgages and all the paperwork. But again, there were people doing it like mortgage reps or people who weren't really anything. They would be in some other job, not even related, and they were doing these forensic audits. Now, I understand, of course, from you how it works, but maybe you can explain to the listening audience what a forensic audit is and why it doesn't work.
Are you talking specifically about these forensic loan audits, securitization audit, chain of title audits?
Yes,
why they don't work?
Exactly.
Because the underlying argument doesn't work. Securitization, here's what everybody misses. They think securitization just started in the last 20 years. They've been securitizing notes in this country since the 1700s. So securitization isn't illegal. It's not a new concept. It's been going on for years. Everybody that's ever argued securitization is lost. That's one of the many stall arguments that these scammers and stall attorneys use. The question before the court in a foreclosure is, did the homeowner breach the contract by failing to make timely payments? Well, if you say to the judge, my loan was securitized. Okay, how did that cause you to miss payments? Well, Your Honor, my loan didn't get into the trust in time. How did that cause you to miss payments? That's the question before the court. All of this other stuff is just a lost leader. It's a red herring, and it's just a way for for a stall attorney or a scammer to convince the homeowner that, look, our arguments are great. It's just that the judges are in the bank's pocket, which is total nonsense.
Now, years ago, I had someone who was a real estate investor draw me out on a tablecloth a huge chart of how, securitized items are bundled and sold off to different companies. From the financial perspective, he seemed to know what he was talking about, but he was trying to do something, and I don't think it ever worked. The other thing I do want to mention is the straw man theory. I know someone that they claim the straw man theory works. Can you explain a little bit about that? Because we know it doesn't work. It's another scam.
Well, the straw man theory is another one of these theories by these tax protesters and, quote, sovereign citizens and other crackpots that basically say that your name in all capital letters is really not you. That's why you see them in capital letters in the lawsuit, and they're always in capital letters. Well, they put your name in capital letters because that's basically the title of the case. They're not going to put it in lowercase levels. It's nonsensical arguments. It's just a lot of stuff that's made up by scammers in order to get individuals to listen to the arguments that they're making. And again, their fallback position is when the homeowner loses is that I told you up front that the judges are in the bank's pocket. You lost because the judges are in the bank's pocket, which is total nonsense because the law that the courts are citing are 150 to 200 years old. Okay.
So, in these sovereign citizens, they also, I believe, they say that the United States of America is a corporation. would that be that would, when it relates to the straw man theory? So what do you think about that?
Well, for purposes of suit and things like that, a government entity is a corporation for purposes of a lawsuit, but as far as something that's going to help somebody in a criminal matter or in a civil matter, foreclosure, it's not going to help. It's just a bunch of nonsense.
Yeah. Now I've got one more, and I disassociated with people who do this because I used to know a couple of realtors. I figured out what they were doing, which was when a homeowner was in trouble, they would have the homeowners sign over the deed to, for example, to the realtor. And then the realtor would put that deed in a trust in the attempts to try and negotiate something out with the bank. But if they weren't able to do that, then, of course, the homeowners no longer had that deed, so it went right to foreclosure, and yet it seems like there was no liability on the realtors, correct? Not many of them, anyway.
A lot of people have gone to jail doing that because what they would do is they commit bankruptcy fraud because they would put something into a trust, and then when the bank came in with a motion to lift stay, they'd move it into another one. They'd file another bankruptcy based on that one, and then they do it again and again and again and again. And a lot of people that were doing that have gone to prison for doing that because it's bankruptcy fraud.
Okay, so is it possible for someone to save their house legitimately without, I guess, a legitimate bankruptcy if they would have to make enough money, obviously, to pay the mortgage?
Well, that's correct. I mean, matter of fact, the Office of the Comptroller of the Currency even put down at one of their foreclosure rescue scams is bankruptcy for a foreclosure, because a bankruptcy 99% of the time is not going to help you, and here's why. You not only, if you were to file a Chapter 13 bankruptcy, you not only have to pay your mortgage and your other creditors, you also have to be able to pay back the arrearage in 5 years or less. So a lot of these homeowners, let's say they have a $1,000 a month mortgage payment, that's $36,000. Their mortgage payment is $1,000. So they have to make their $1,000 mortgage payment. They have to pay all of their other creditors, whatever that may be, maybe cars, maybe credit cards. And now they have to pay back the $36,000 to boot, plus the percentage that the United States trustee takes. And they, in the majority of cases, they can't do it.
Gotcha. Now, I mean, I know you've helped shut down some of these scam companies. I know the law changed years ago. I believe now it's only lawyers can charge upfront fees if they're trying to do some type of, assistance to the homeowner. Is that correct? And no one else can charge them a fee?
Well, actually what happened is there was a lot of companies that basically were scamming homeowners by telling them they could get them a loan modification. And the homeowner would pay this. I saw at one point as high as $7,500 to $10,000 these loan modification companies were charging to do a loan modification. Well, what would happen, a lot of them were illegitimate, and they would basically tell you that they're going to get you a loan modification. They wouldn't do anything. You'd have no idea if they did anything or not. They'd get foreclosed on, and they'd say, well, wait a minute, I never got a loan modification. Oh, well, they turned you down. Well, they had no evidence whether they were accepted or turned down at all. The legitimate ones, they were charging money, but, a lot of people don't get loan modifications because they don't fall underneath the computer algorithm that they have to give loan mods. So a lot of people started complaining to the attorneys general around the country, so they passed a law that you couldn't charge money to do a loan modification until it was concluded. So that is what gave birth to the securitization audits and the forensic loan audits, because these people who were doing this said, well, we can't make any money doing loan modifications now, but let's do these securitization audits, which turn out to basically be a scam as well. So that's how it's grown.
So the criminals the criminals are always one step ahead, basically. If something changes, they modify. If something changes, they do something else. And they keep doing things as long as they can get the money from the homeowner, who really there are other options that are much better. But let's do this. Let's go to a commercial break. And when we come back, we're going to have Bob Hurt, consumer advocate, with us. So stay with us.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
Well, Laurie, we're back on AM FM 24/7 radio. The call-in number for listeners is area code 646-668-8512. And I believe that we have consumer advocate Bob Hurt on the line. Is that true, Jason?
Bob, are you with us?
He's not on yet.
Oh, he's not on yet? Okay.
He's not on yet.
Well, that's right. So, Storm, I have one more, and this one were people I met probably about 3-4 years ago. And a couple of fellows, one I knew, and they had a company. What they did was they purchased homes that were in foreclosure. They actually paid you, if your home was in foreclosure, a percentage of the value of the home. Let's just say, I think it was around 15 to 20% at the time. Of course, the homeowner, again, would have to sign over all the paperwork, and I think they somehow worked with the homeowner, this company, and the company itself would have an attorney that would fight to try and get the house. But the downside of it, and I don't know if they ever got anywhere, the downside of it was if they won anything, they were actually winning a lot more money if they were to win. So I thought that was sort of a creative one because, every time I read articles about foreclosure rescue scams, I sit here and I go, why doesn't any authority do anything about it? Why doesn't, the bar do anything about it? Why doesn't the Attorney General? And I know the answer to that question you're probably going to tell me is, hey, there's not enough people. Well, then there's something wrong with this world if there's not enough people to stop the criminals.
Well, you got to remember, again, you have these scammers and stall attorneys inoculating these homeowners up front with the idea that the judges are in the bank's pocket. So when the homeowner eventually loses their home after spending, in some instances, tens of thousands of dollars, the lawyer says to him, well, hey, look, why are you complaining? I've kept you in your house the last 3 or 4 years. Well, that's kind of a lie in and of itself because in judicial states, from the time a homeowner misses their first payment till the time they get thrown out of their house is a minimum of 3 years if they do nothing. So, and what kind of condolence is that, okay, well, now you get thrown out of your house and you get embarrassed and you spend $40,000. I mean, it's just total nonsense. So, I mean, it's one of these things where the poor homeowner doesn't know and understand how things actually work, so they buy into it. I mean, I see every day where people say in these Facebook groups and things like this how the lawyers basically screwed them over. Again, nothing's further from the truth. But I will tell you, there is some things that It very rarely happens, but we've always told our clients that here's something that you could possibly do to save your house outside of having it analyzed, and that would be if you could find a benefactor that would be willing to come up with the money to buy the note. And lots of times the note holders are acceptable of this because they buy these notes 30 to 50 cents on the dollar, or even less. Fannie Mae and Freddie Mac last year sold $18 billion in non-performing notes. And these pension funds and hedge funds buy them, and other note holders buy them. So let's just say, for the sake of argument, that it's a $200,000 note, and let's do it at $40,000. At 40% of that amount. They paid $40,000 for that note. Okay, now what they can do is, if they have to foreclose, it'll in judicial states it costs them about $70,000 to foreclose. Okay, so what they'll do sometimes is if this homeowner can find a benefactor, that benefactor, the note holder might accept. They only paid $40,000 for it. They may accept $50,000. They may accept $60,000, and it's off their plate. They don't have to spend the $70,000 to go to court, and all that time period that it winds its way through court, which sometimes can be 5, 6, 7 years. They're not getting payments. They're willing to accept these payments up front. But it's a rare occasion that a homeowner has a benefactor that would have that kind of money in order to pay off the loan for them.
Right. Now, let's see. Has Bob joined us yet?
No, he has not come on yet.
He hasn't come on yet? Okay.
Yeah, he's not
so
on
you'll let
yet.
us know. Okay.
I will.
So, Storm, thanks. The other thing I've seen in the past are the leaseback repurchase scams. So, that's again where the homeowner signs over the deed to whoever is leasing it, and then they basically lease back their own property. But I understand that's a scam also.
Yeah, because you can't have somebody. Lots of times people go to jail doing this as well. But these short sales are supposed to be arm's length transactions. The homeowner's not supposed to be involved in any way, shape, or form, or any of their relatives or friends or anything like that. And so they have people that will do that. But that's a criminal act in and of itself. It's not a criminal act for you or I to go to a friend and say, hey, I've talked to the bank. The bank is willing to take $50,000 on this $100,000 note. Can you lend me the $50,000? Well, that's not criminal. But if you have some short sale deal where it gets short sold to somebody who's an acquaintance or a friend or something like that, that's basically scamming the bank. And people get caught and they end up going to jail for it.
So, I want you to kind of explain what an arm's length transaction is, because one thing I never understood is let's say that happened to me and my mother wanted to come in and buy the house. She couldn't do it because it wouldn't be an arm's length transaction.
Your mother could come in and buy the house. But why would she come in and buy the house? Why not just give you the money to buy the house? See what I mean?
Because once you're in foreclosure, a lot of times the bank won't even accept the money once they've already filed the lawsuit.
Trust me, they will take the money. They'll take the money. They want the money. That's why, not only do we analyze mortgage transactions, we analyze these notes for the pension funds, hedge funds, and note holders. We know what they pay for the notes because part of what they do when they come to us to analyze the notes for them is, should we buy this note? Because lots of times they'll advertise notes that, not Fannie Mae or Freddie Mac, but what happens is the pension funds and hedge funds are the ones that have all this money to buy these notes. They buy thousands of them at a time. And they kind of cherry pick the ones that they want, and then they sell off these notes to people kind of lower on the food chain. They buy them and they kind of cherry pick the ones they want and then sell them to other people as well. Well, lots of times what they'll do is they'll advertise these notes as reperforming notes. Now, a reperforming note is someone who wasn't paying the note, but now the note holder did a loan modification with them and they're reperforming. Well, reperforming notes sell anywhere from 50 to 75 cents on the dollar. So what happens is you and I go out to buy a note. They're telling us that they're reperforming notes, and then in actuality they're not. They're non-performing notes, so we shouldn't be paying 50 to 75% of the dollar. We should be paying a whole lot less. So we analyze, those notes for them. So it's, again, it's like anything else. I was talking to an attorney over the weekend, and I told him, I said, it's like anything else. When there's mass hysteria, if you will, like there was in the foreclosure crisis, when there's hurricanes, people go out and they start selling cases of water for $500. Anytime there's something going on like that, the scammers are out there. They're trying to, screw the public. So, again, the courts have said it. We've said it. Anybody that has, even people with a low IQ, understand that a foreclosure is a breach of contract case where the homeowner breached it and they told the bank, take the house if I don't make payments. Well, anybody that, as I say, has two brain cells to rub together would understand that the only way to overcome your breach would be to find something wrong with that contract. It's the only thing that works. And if anybody's telling anybody any different, they're lying to them and they're trying to scam them out of their money.
Right. And I think the other way, too, is was the house overappraised? Because back during that time, I don't know if it's still going on, but a lot of appraisers felt like they were going to lose their jobs if they didn't appraise the house to what the realtor wanted them to, appraise it to. And so, after the bubble burst, a lot of appraisers moved out of state here because, there was no work left because they overappraised.
Yeah, well, what was happening, and this is on a nationwide basis, by the way, the Federal Deposit Insurance Corporation, they went out and analyzed a couple hundred or so mortgage transactions and found that 83% of the mortgages were problematic and 76% of the appraisals. And what was going on with the appraisals, they can't do it anymore because they changed the law on it, but back in the last decade, what they would do is the mortgage broker would call someone on their approved appraiser list, which they can't have any longer, but they had then. Hey, Joe, I need for you to come back with $400,000 on this property so I can do this loan. Well, Joe, the appraiser would go out, he'd come back, he'd say, well, it's not worth $400,000, it's worth $290,000. And the broker would say, hey, Joe, need I remind you that you're on our approved appraiser list, which you won't be any longer unless you give me the $400,000. Well, Joe, the appraiser wanted to keep the roof over his head. So he looked at it and said, hey, nobody's really ever going to find out. I'm just going to go ahead and say it's worth $400,000. Well, in essence, what happened? When you borrow money from the bank, you are buying money. So you're paying for a product that's not worth what it's purported to be. It would be like going out and have a jeweler telling you this ring is worth $5,000 when in effect it's worth $2,000. Well, if you knew it was worth $2,000, you wouldn't have paid $5,000. So these homeowners were fraudulently induced by appraisal fraud. And that's the other thing that we tell people is say, look, think about it. Even if a securitization audit was viable, which they're not, they're just a scam, there's 76% of the time there was a problem with that appraisal. Now, when you're talking appraisal fraud, you're talking punitive damages. Those are damages that are used to punish the wrongdoer. That's why in the case of Quicken Loans versus Brown, Miss Brown was awarded $3.6 million and $700,000 she got out of the appraiser in a settlement for overappraising her home. We see this all the time in a lot of states like Florida, California, Arizona, Nevada. New York, Illinois, we call foreclosure capitals. We see appraisal fraud as much as 90% of the time. So here the homeowners have viable claims that they could use, but they don't know about the claims. We tell clients, we tell them in seminars, we tell them everywhere. Look, you need to understand something. You are not going to win your case unless you have some evidence of wrongdoing against somebody. That somebody, depending upon the factual scenario of your case, could be the person who sold you the home, could be the real estate agent, could be the mortgage broker, could be the bank, obviously, could be the title company, could be the appraiser, could be your own attorney that scammed you by not having your transaction analyzed. We do these analysis for homeowners all the time, and they wouldn't have lost their house because as we did the analysis, we found all these things wrong with the mortgage transaction that the homeowner could have used, but because the attorney was doing nothing but stalling, they lost their home. But now they have a claim against their lawyer for malpractice.
Yep, and so I've got more on that. But you know what? Let's go to a commercial break. If you're listening to the show and you'd like to call in and ask a question, you can call into 646-668-8512, and we will be right back.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first, identify errors that would void the contract, identify regulatory violations, identify appraisal fraud and other fraudulent contact, and the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
Well, Laurie, we're back on with AMM 24/7 radio, FM radio. Call-in number 646-668-8512. And I don't know what happened to the other consumer advocate, Bob Hurt.
Well, I'm sure if he calls in, Jason will let us know. I want to ask you some more questions, though. So, you know, when you have an appraiser that overappraised the value of the property, because there's still a lot of old foreclosure houses around, the appraiser is considered an agent of the bank, correct? So if you were going to go to court to say, you know, the appraisal was way too high and you had proof of that, I'm assuming that you would sue both the bank and the appraiser?
Well, in actuality, the appraiser is paid by the homeowner. If you look on the settlement statement, you, the homeowner, paid for that appraiser. What makes a bank culpable is in their underwriting departments, they have appraisers that are supposed to look at the appraisal to make sure that the appraisal was done properly. Because they don't do that, that's why Quicken Loans had to cough up that $0.6 million, was because those appraisers in the underwriting department just let it, fly through, which they were doing back at that time because you had millions and millions of people trying to get loans. These banks were flooded, and as this stuff was coming in, they were just kind of,
greedy.
Looking at,
greedy.
Just pass it. It wasn't so much greed. It was just this, get it off my plate. That's like us at Mortgage Fraud Examiners. We only take on so many new clients a month. We do that because we know human nature, if you've got a bunch of stuff on your plate, you're doing everything that you can to get it off your plate. And you can't do that when you're looking at documents. So when these documents were coming into these banks, they were getting this stuff out the door as quickly as possible. That's why there were so many statutory regulatory violations of these, because it wasn't so much that the bank was doing it purposely, which these scammers would like everybody to believe. They were just negligent. They just had them pass through. They were selling them to somebody in Dubai, in China, or whatever the case may be, or to Fannie Mae. They didn't care. Let's just get this stuff. Let's get it in, get it out the door, so we can get our money back and do it again.
But I find it stormy. I find it disturbing because, we call it the bank. The bank is made of people. The bank is made of executives and managers who make these decisions. And at some point, maybe somebody in each of these banks should have said, stop, wait. And I say that because I actually know someone who was a bank analyst right before the bubble burst. He got out because, these mortgages were coming across his desk. And he's telling, I don't remember which bank it was, but he was basically telling the bank, I'm not signing off on any of this. The house is not worth the value of what it is. And so he completely, switched careers, left his job, and said, I can't do that. How come you don't hear that many stories of people doing that? Is it because they're afraid they're going to lose their job? Because I sit here and I go, the moral principle of helping someone is if you're truly helping them, you're trying to help them. But if you're doing it because you work for a big bank and, I understand everybody has to eat if you have a family and things like that. But there's a moral issue there for these people who allow this to happen, and yet you rarely hear about any of them, once in a while, but you rarely hear about any of them going to jail, and yet you read all of these articles on, Ocwen and Wells Fargo and, Bank of America. I mean, they've all been in some type of trouble at some time, but no one really goes to jail. And even if they pay fines, those fines go where? To the Consumer Financial Protection Bureau? Where do the people get their justice?
Well, that's why you have to analyze your transaction and go after them that way with proof. Now, this guy told you as a bank analyst, well, I hear these stories all the time. Let me tell you why I don't believe the story. Because, again, there are very specific people within the underwriting department that are appraisers that look at these appraisals. This guy, unless he was an appraiser, he can't say whether or not the appraisal is any good or not. So lots of times, a lot of these people that leave, it wasn't so much that they were trying to be whistleblowers or that kind of thing was. They got fired for some reason, for being incompetent. Maybe things were coming across their desk and maybe they were caught not looking at this stuff. Again, as I try to point out to people, they need to understand, Laurie, if I came to you and said, Laurie, will you lend me $300,000? And you said, sure, Storm, I'll lend it to you, but I need a promissory note and I need a mortgage because if you get run over by a bus, I want to make sure that I get my money back. And if I can't get my money back, I could sell the property and get my money back that way. Okay, now, how could you possibly have defrauded me by giving me what I asked for? You can't.
I'm not sure. Okay.
You can't defraud me. Now, in drawing up the contract, there could be negligence in drawing up the contract. You and I agreed that it was going to be at a 5.5 interest rate, and you put down 5.75%. Again, which is unique to mortgage contracts, they have to follow specific statutory statutory regulatory mandates that they have to follow. Maybe they weren't followed. If the appraiser, if there's a problem with the appraisal, well, again, the underwriting staff, the appraisers and underwriting staff should have looked at that. Again, these loans were coming in such magnitude that they were getting them out as fast as they could. But when you say that this person, specifically, or this bank specifically committed fraud in that context, That's not true. Now, what these banks were doing is they were selling notes to Fannie Mae and Freddie Mac. Fannie Mae and Freddie Mac the GSEs own 98% of all non-jumbo loans in the United States. So they, they were misleading them. They weren't scrutinizing the documents as well as they should have been doing. That's negligence. That's not fraud. That's not a crime. You have to plead fraud with specificity. How, when, why, who specifically did it, how did they do it?
What about all those people that robo-signed or robo-signed for multiple companies, even sometimes on the same transaction? They worked for all three companies and everything, and it was robo-signed. But most of those people didn't end up in any trouble either. They say, we were just told we had to do that, or somebody else signed someone else's name when on a lot of these documents was another defense.
Well, I can allow you to sign my name. I can let you do that. But robo-signing, again, when it comes down to the foreclosure part of it, a judge is going to ask you, Laurie, how did that cause you to miss payments?
It didn't.
It didn't.
So really, what you're saying is you got to skip from point A right to point B with nothing in the middle, because whoever holds the note gets the foreclosed.
Exactly, because you got to remember something. You and I and every other homeowner, and most of these contracts are standard Fannie Mae, Freddie Mac contracts. We signed the contract, okay? Now, most people didn't read them. That's no excuse. You have a duty to read. You can't say, well, I didn't understand what I was reading. That dog don't hunt. So none of that stuff works.
I'm going to agree with you on that part, but let me just say something. Most people are not attorneys. So when they go through these documents, they're written at such a high level. I don't think most people actually understand what they're signing. They're not familiar with the terms. They don't know what it means. And you know what? So what if they go to a title company? Unless they actually hire a lawyer to represent them, like when I bought my first house, I didn't work with a realtor. I worked with an attorney who basically did everything, and it was all done legally, and there were no problems. And I almost think it's a better idea if you're buying a house to have an attorney review everything that's being done to make sure that there is no mistake.
Absolutely, because let's say the attorney's $250 an hour. You pay him $250, and guess what? If there's a problem with that contract and he didn't catch it, who do you have a claim against? You got a claim against that attorney.
Right.
But you can't come to court. I mean, how would you feel if we went to court and I had this contract with you you lent me $300,000, I stopped paying you, and then we go to court and I say, well, Your Honor, I didn't understand any of this, and the judge says, you poor thing. Oh, you poor thing. You didn't understand it. Laurie, go ahead and get out of here. You're not getting your money. Poor Mr. Bradford didn't understand what he was reading. What the hell would you say?
Yeah.
What kind of nonsense is that? Again, it all comes down to this is a contract, and we breached it if we're not making payments. We have to overcome our breach. That's what works. Nothing else works.
All right. Well, Storm, let's do a commercial break. We come back. Let's talk about what Mortgage Fraud Examiners does a little bit more specifically so people understand it, because you're the only company of your kind. So stay with us. We will be back in just a moment.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
Well, we're back on AM/FM 24/7. The call-in number is 646-668-8512. I'm with my co-host, Laurie. Laurie, you're going to ask a few more questions or make a few more statements regarding homeowners getting scammed?
Well, yeah, actually, one of the biggest scams I thought was when the banks would tell people that they had to be 90 days late in order to do a loan modification. And, that's hypocritical. That's a paradox, because if you were 90 days late on your mortgage, your credit scores will drop so low that no one would give you a loan modification or refinance. Or if they did, I know a lot of people that said, hey, I had a temporary loan modification with whatever company it was, and after 3 months they decided to move forward in foreclosure. And not one of those people told me they had a written loan modification agreement. It was all verbal. So I guess my questions to you are, do people have to wait 90 days in order to try to negotiate a loan mod? I hear yes, I hear no, but I always think as far as even a temporary loan mod, you got to get everything in writing, because verbal doesn't really count.
Exactly. That anybody that told a homeowner that they had to wait 90 days in order to get a loan mod, that's a lie. Basically, what they were telling you to do was to breach the contract. The problem is, and again, the homeowners that take the time and are smart, what they do is because, trust me, that person who's making $7 an hour that has purple hair, tattoos all over their body, and a razor blade in their eyebrow doesn't know what they're talking about in the first place. And I can guarantee you there is no way, no how, that person is ever going to come into court and say, yeah, I told them that. They're not going to do that.
Right.
So it's necessary and imperative that when you're talking to anyone on the phone, put it in writing.
Right. Now, but keep in mind, though, a lot of banks, wouldn't put anything in writing. That was the problem. Now, I always learned if a company wouldn't put something in writing, I get a specific name and title and mailing address to that person I spoke with, although a lot of times you had a hard time doing that from what I hear. But I would try and then send them back a summary of everything we spoke about and send it back certified return receipt mail. So at least if it went down to court, I would have something to prove that this is what I said versus the bank. Because, these $7 an hour people doing, the loan modifications telling you, hey, wait 90 days, that was the thing. And so, in a state like Florida, you cannot record the call unless you have dual party consent, which we don't have here. So why didn't these people get in trouble? I mean, if someone said something to someone through their phone systems, through the banks, they can see when the call was made and by what number it was made and by how long it lasted, and they keep those recordings usually for a couple of years. I just go, all these people.
That's a ruse. That's a ruse. They really don't record anything. They're just they're telling you, we may record this. For quality insurance, we may. Not we are, we may. So you come to find out, they're really not recording anything. But what you can do, what you just brought up, yes, in a lot of states, it's against the law if you don't tell the other side that you are recording it. Anytime that I get a phone call, and I don't care what it's about, if they say, look, we record this for quality service purposes, blah, 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 blah. You know what I tell them? I'm recording it as well.
Yes.
Now, if they're legitimate, hold on. If they're legitimate, they'll say, okay. If they're not legitimate, they'll say, well, you can't record. Well, if I can't record, I'm not talking to you. Bye.
Right. I understand what you're saying. A lot of them, they'll state that it's under the Fair Debt Collection Practices Act, and they are recording the call. Not that they may record it, but they are actually recording it. And so if you say, well, I'm going to record this call too, they'll say, most of the time they'll say, well, no, sorry, I'm not allowed to do that, and hang up on you. And at that point, if they're not willing to let you record back that call, my gut instinct would be hang up. You want everything in writing, right? Everything should be in writing.
Exactly. That's how you protect yourself, because it's like contracts are like locks. They're for honest people. You don't think a crook doesn't know how to get past a lock, do you?
No, I mean, of course they do.
Yeah, they're for honest people. that they're not going to, if the door's locked, they're not going to come into your house. Crook, he's going to come into your house. The same thing with this other stuff. I mean, nobody is going to, do something that's going to be detrimental to themselves. Again, you were smart. I do it all the time. Hey, you want to talk to me? You're recording the call, so am I. If they don't want to talk, I don't talk to them.
Right.
But you got to remember something. I tell everybody this, and I hear the scammers, the loan modification scammers say, oh, well, no, they don't help. Look, as an experiment one day, I got on the phone, I called up HUD, and I said, look, I'm trying to get a loan modification with a company. Can you get on the phone with me and talk about that? Absolutely. They're willing to get right on the phone. And it came clean. I said, look, I was just doing that as a little experiment so I can say that I have firsthand experience in doing it. Oh, yeah. We're more than happy to get on the telephone with someone if they're trying to get a loan modification.
Okay. Do you have to disclose that when you're calling the bank to do the loan modification, that there's a third party on the line?
Yeah. You just tell them, say, look, or actually they'll do it. They'll get on for you and they'll say, look, my name is, Joe Blow from the Housing and Urban Development. I have on the phone one of your clients, Mr. Bradford. It's loan number so-and-so and so-and-so. We wanted to talk to you about a loan modification.
Okay.
As I tell people all the time, look, there's government agencies that will help you. The courts will help you. But nobody can help you if it's a foreclosure case where they come and take your house. None of those entities can help you if they don't know what happened in your mortgage transaction. Not what happened after the fact. What happened in your transaction. We find where banks have breached the loan modification agreement. So it always comes down to that contract, because that contract, again, is for honest people. Because, look, Laura, you and I can have a contract that's verbal, and you remembered it one way, I remembered it another way. You're not trying to scam me. I'm not trying to scam you. That's just how I recalled it. That's just how you recalled it. But we don't have to do that if it's in writing. Because
that's why I put everything in writing, Storm. For anything I do, I put everything in writing because you're right. It clarifies all the thoughts. There's less chance of misunderstanding by either party when you're working out something in writing. If you just do it verbally, people will go, well, I don't remember saying that. You're relying on your memory for everything. No, it has to be in writing. And so that's why one of the things I always learned, like I said, whether it's, for mortgages or whether, you own an appliance that broke down and you had a phone call with them and they said they'd fix it, and they don't, then you have to send them back a letter, certified return receipt mail, and summarize it and say, this is what you told me, Jane Doe, and now I want you to come and fix it. You're not returning my calls. You have something in writing that confirms that verbal agreement.
See, here's the difference between you and the regular homeowner. You're a consumer advocate. You know about the scams. You know about how things can be misconstrued and everything else. The typical homeowner doesn't. So what they do is, again, this is a known medical fact. I've read it many times, that the human brain, the logic center of the human brain shuts down when people are under stress and they're afraid. Well, somebody that's looking to lose their house is afraid and they're under stress. So they buy into some of the most ridiculous things that you and I have ever heard. I mean, one of the best ones is that everybody has $100 million in a treasury account, and their Social Security number is the number to withdraw your money. I have people that call me up and they try to tell me this nonsense. And my whole thing is, excuse me, what mental institution are you in that has phone privileges? Because you have to have a mental disorder to believe something like that. It's total nonsense. But these scammers are out there selling it. And there's not a few of them. There's tens of thousands.
Yeah, but they're selling it because people are scared and they're preying on these people a second time. And then if the person gets a lawyer who's a pretender defender, there's your third time. And so it doesn't seem like anyone, you stand for the consumer, me, I stand for the consumer, but there should be better legislation to protect people who lose money in transactions like this when the contracts are breached. The whole thing, I mean, people sit here and go, what the hell happened then? Like, how did it all happen? It just blew by, the rocket docket, no one had a chance to speak.
Well, okay, Laurie, let's look at it this way. I'm a judge. You come into my court. I know why we're here. We're here because Laurie breached the contract. That's the question before the court. Did Laurie breach the contract? Because that's what the bank's alleging. Okay? Well, all the bank has to do is to be able to show they had the note, or if not, a lost note affidavit, and they have to be able to show in the contract where you agreed that if you failed to make timely payments, the bank could take the house. And then the bank's going to say, Your Honor, here's the proof she didn't make timely payments. Now, I turn to you, Laurie, what say you? What say you? Your Honor, my loan was robo-signed. Yeah? How'd that cause you to miss payment? Well, it was securitized. Well, how'd that cause you to miss payments? Well, MERS was involved. How'd that cause you to miss payments? Didn't get to the trust in time. How'd that cause you to miss payments? Laurie, right. We're here because you breached the contract. Please tell me something. Is there an error in the contract? Were you fraudulently induced into the contract? Did they not follow any statutory regulatory mandates? Your Honor, Laurie, give me something that I can help you. If you don't have that, he's going to allow the bank to take the house because he has to uphold that contract.
Right. I understand.
If you look at all of the cases out there, all of these arguments, securitization, MERS, produced the note, didn't get in the trust of time, robo-signing, assignment, standing, nobody's ever won. They've stalled foreclosures, but nobody won. And the courts are saying every day, the promissory note and mortgage is a contract. We have to follow the four corners of the contract. They say it case after case after case. I mean, the courts are telling you this isn't something that I made up. This is something that the courts have said.
All right. Well, we're gonna close out here, I think, because I think we covered a lot of good information for our listeners. And if they want to contact us, they can go to Facebook to the Fraudsters Radio page. We look for story ideas, or if you've been scammed in some way, we do want to hear your story. And Storm, they can reach you through mortgagefraudexaminers.com and read a bit about the information in the press releases. I think that kind of helps help people see how it actually works. Any last thoughts? We got about a minute to get off.
Well, I guess, to end the show, the most important thing is we try to tell homeowners, look, if you're going to go hire an attorney, first question is, and you already brought it up, have you ever done a foreclosure case before? If the answer is none, walk away. If they say, yeah, I've done them, well, how many have you won? Well, I haven't won any. Walk away. If they say, I've won some, say, look, what's your definition of win? So
you want to see the court cases where they've actually won. I totally get it.
And then one of these scammers, securitization audit scammers, some other scammer, and guys, they're selling these foreclosure defense books. They're factually and legally incorrect. They're nonsense. You see people on videos. They have no idea. Some nitwit in California who ran for Congress out there, thank God he lost. But he has these videos. He doesn't even know the names of the cases. The famous Jessenowski case for tiller rescission. He called it the Oblansky case. He filed a frivolous lawsuit in district court. Couldn't file a lawsuit. He committed an unauthorized practice of law by representing somebody. He's not a lawyer. You can't do it. And, so you have people out there. You just really, if it doesn't make sense, it's nonsense.
Perfect ending to the show. So I want to thank all of our listeners for joining us today on Fraudsters Radio. Please join us again next Monday from 1 to 2 p.m. Eastern Time live. Remember, we do want to hear your stories, and you can contact us through the Fraudsters Radio Facebook page. Thanks, Storm. Another great show.
Thank you, Lori. Bye.
Bye-bye.